This is an election year for judicial candidates. We had the primary. We only had 2 million voters come to the primary instead of the 8 million that appeared in November via either appearance or by mail-in ballots. So we will have an election in November for the judicial candidates. PMC will be having a judicial candidates forum in September, so stay tuned, but I urge everybody to educate themselves and vote. Okay, that was my little public service announcement. And now I want to introduce Flora Novick and say thank you, Flora, for doing this. Flora is the Philadelphia Bar Foundation's board observer for PMC. It's a great program where young lawyers learn about being on a board without having any kind of financial commitment, but there's a program which teaches them about boards, financial, how a nonprofit is run, what types of involvement is expected. Flora graduated from Temple Law School. She worked as a trust and estates attorney for a few years and for some private firms, and now she's currently senior management associate at Glen Mead. She's also a member of the Philadelphia Estate Planning Council, and she helped PMC with this program, and for that we very much appreciate it. So I'm going to hand this over to Flora. Thank you. You're muted.
Sorry about that. I think I would learn by now. Welcome. I'm really happy to be here. PMC is a really amazing organization. I worked as an attorney for 5 years and definitely noticed how much better off people were when they were afforded effective representation and also equal access to the courts and having equal access to transparency about the judicial process. So tonight I'm excited to go through the process of administering an estate, which is something that most people can do on their own without an attorney and save quite a bit of money. So I guess we'll start it off. I think Debbie is gonna, I guess you already talked about PMC. So I'll just get right to the meat. All right, so when a loved one passes away, generally one of the first things you want to do after planning for the funeral and all the personal things is look to see if they have a will. If they do, you take that original will right away to your local register of wills, and that is something you can look up the address to online. You just type in whatever county you live in, you type in Cumberland County Register of Wills, and that will give you the address. And it's good practice to just give them a call and find out exactly what they require in their county. It's supposed to be uniform across the state, but it's not. Basically, if there's a will, you want to probate it, and when you call the Register of Wills, they'll let you know exactly what forms you need to fill out and exactly what steps you need to take to begin the process. So one thing you might want to ask yourself, especially if there isn't a will, is whether you need to probate an estate at all. So there's things called probate assets and non-probate assets. So non-probate assets are anything that an individual owns that has a transfer on death beneficiary. So most bank accounts, people will list a beneficiary with their actual bank. Most retirement accounts, the same. Any accounts that are joint, that the decedent owned with another individual, as long as they're owned tenants by the entirety or joint tenants with rights of survivorship, none of those assets pass through probate. So if the decedent had no assets, if they had all assets that had a beneficiary listed or were joint, you don't need to probate an estate. However, a lot of decedents might not necessarily have listed a beneficiary. They might have owned real estate or other property that did not have a joint owner or a transfer and death beneficiary. And that's when you need to, if you would like those assets to transfer to whoever the testate or intestate heirs, then you need to probate an estate. So what is your name? Because I know you're on here, and you don't have to give that to me. But if you want to ask questions, I can kind of tailor it to you if you would like. If you know whether there's a will or not, because it is very different. So if you guys want to just let me know if you're considering if you have questions about whether they're an estate that has a will or doesn't have a will, you can let me know and I can tailor it, or I can just go through both.
Flora, I think you should just do both, because we have a few different people on, and so so this could be, and since it's Zoom, people could be from all over the state. I mean, unless
I only see one person.
Oh, so, yeah.
Ask her, but I guess there are several other people on. Okay. Okay. So.
But I guess if people want to put where they're from in the chat, that'd be great too. And that could help. Or even if you're interested, we'll look at the chat, pay attention, and try to tailor the program to you as well, just so you know.
Okay. And because I'm sharing, I can't see the chat. So if you.
Okay, I'll monitor it and tell you.
All right, so this last slide, sorry, we talked about this before we got to the slide, but this goes over whether or not you need to probate an estate. It just depends on what type of property the decedent had and how it was owned. So this question, a lot of people ask whether or not they need an attorney to probate an estate. You don't need one to probate. You're not legally required to have an attorney to administer an estate. However, if you feel, if it's a substantial estate, or if you feel like there could be potential litigation involved, it is a good idea to consult an attorney. And there are inexpensive and free legal services available to members of our community if you feel that you might need help just in the beginning to get you started.
And so I'll interrupt you. There are a number of people from Philadelphia, for example. The Philadelphia Bar Association has a very active trust and estates practice. I know there are other county bar associations that also have a very active trust and estates section. So, that's always a first place to begin if you wanted to figure out how to reach out to an attorney, for example. Sorry.
No, that's perfect. All right, so we'll go over testate and intestate. Testate means that the decedent died with a will, and whoever is listed in the will as the executor is responsible for probating the estate. So the executor is responsible for taking that will and bringing it to the Register of Wills. And if they would like to serve, then they get sworn in with the Register of Wills. If the executor named in the will does not want to serve, they can sign a renunciation with the Register of Wills, and the next person named, if there's a successor executor listed in the will, that next individual has the first right to serve. If no one wants to serve, the executors can renounce in favor of someone else, and as long as all of the beneficiaries sign off and all of the individuals entitled to serve as executor sign off renouncing their right to serve, then whoever they nominate can serve as executor.
And Flora, when you say renounce, do they have to sign a piece of paper to confirm that?
Yep. So so again, this is one of the things that it should be uniform, but it isn't always. So the county Register of Wills will let you know, but it is a form called a renunciation, and it's just pretty much a simple, a simple title. It's going to be called a renunciation wherever you go. But the counties have different rules on whether or not you need to sign that renunciation in the presence of the Register of Wills, or if you can sign that in front of a notary and send in an original copy. So it's always good when you, if the person named wants to renounce, to ask the Register of Wills exactly what their requirements for renunciation are. So when someone dies without a will, then the decedent's next of kin will be named as administrator of the estate. So the administrator and executor have the same roles and responsibilities, they're just called different things. So an administrator of the estate, if a decedent dies with a spouse, the spouse has the first right to serve. If she doesn't want to, or he doesn't want to serve, they can renounce in the same manner that they would renounce if they were named in the will. And then whoever the next of kin, if there are children, then all of the children would have the right to serve. If just one of them would like to serve, then the other children and the spouse would need to renounce in favor of that, the child who would like to serve. You have to be a US citizen to serve, and that's pretty much, and you have to be an adult. Those are pretty much the two main requirements. If you don't live, you can serve if you don't live in Pennsylvania, but you have to post bond, which just is an insurance policy. So it says if basically you just pay an insurance policy up to the amount that you think the estate is worth, and it's called a bond. If you live in state, so if you can present your Pennsylvania license, then you do not have to pay a bond. So it could save you about $1,000 on the insurance policy to insure.
I think you also, if you don't have a license, you could just present some mail to an address, is my recollection. Is that correct? Do you know?
That depends again on the register.
And the county, right?
Some of them are very strict, so they want official license. Some of them will accept an address. Again, that is county specific. And a lot of times, I don't know if you've ever dealt with court clerks, some of them are really amenable and easy to work with and want to make your life easy. And some really could not be bothered and want to make you work as hard as possible to get what you need to get done. I'm going to interrupt you and tell you a story about a court. When I was younger and you had to actually go into the clerk's office to file everything. One was really nice, one wasn't. I always make sure I had candy with me to give to the nice person, just so that they could be on my side. So yes, it's just be prepared. Yeah, be prepared. That's one of the things of my really strong advice. When you go in, be as nice as possible. And even if they're not nice to you back, you can't do anything about it because they can make your life easier or miserable. So the nicer you are, the more likely they are to give you free legal advice instead of saying, go ask an attorney. And, the more likely they are to just help you out in general. State laws control the distribution of a decedent's property. In Pennsylvania, if a decedent dies with a spouse and children, all of their assets that aren't owned, that don't have a payable on death beneficiary. So if, say there's a husband and wife and the husband dies with a house that's just in his name, it doesn't just automatically go to his wife, which is the most common, which is the most common rule in most states. It will go to, a portion will go to his children and the rest will go to his wife, even if the children are children of him and that spouse. So that's one of the, a big reason to have a will in Pennsylvania is if you don't, when you pass away, you want all of your assets to go to your spouse and not potentially your minor kids, then it's a really good idea to have a will. So this I kind of touched on already, but typically before COVID, you had to show up in person to the Register of Wills with your ID, with a certified copy of a death certificate, with your with the original will, and with payment. And that was typically the rule. Now it's different in every county. So a lot of times they will require you to fill out all the information ahead of time, send pictures, scans of everything, and then they'll set up a Zoom call with you where you'll sign the probate petition over the phone in front of them. And then afterwards, you'll mail everything in to the Register of Wills, and then they'll mail back to you your letters of administration. So again, very county specific. Philadelphia in the beginning of COVID made it extremely difficult. Montgomery County made it simple. So I think it really just depends on the counties, and most counties are now getting their acts together and making this virtual probate a lot easier. But who knows, as we go back in to work and restrictions are lifted, how that process is gonna change. So again, you're at the mercy of your local clerk. All right, so if there is a will, it makes it easy. You know who's named as executor, you can bring that will in. If there's no will, then you have to determine who the next of kin are. So as I said before, in Pennsylvania, first it's the spouse. If there's no spouse, then it's the kids who have the first right to serve as the administrator. So the next step would be to get a copy of the death certificate, and that you can get directly from the funeral home. They'll provide that. After that, you'll call your local clerk, your local Register of Wills, and they'll give you, in addition to the will and the death certificate, or if there's no will, just the death certificate, you'll need to fill out an estate information sheet and a petition for a grant of letters. So just because you're named as the executor in a will, or you are next of kin, the first in line to have the right to serve as administrator, does not give you the authority automatically to access the decedent's assets or to do anything on behalf of the estate. In order to do that, you have to get what are called letters testamentary, or letters of administration, depending on if you're the executor or the administrator. So that's where you get all the correct documentation, you call your local Register of Wills, you fill out all of the petition and the estate information sheet, and you follow whatever their rules are for getting sworn in. And that really is different in every state. A lot of people will say when someone passes, you definitely don't want to pay any bills or do anything for the decedent until you are sworn in and have access to their bank accounts. The one exception to that rule, I would say, is if there is a home and there's a homeowner's insurance policy. It's really necessary that you keep up that insurance policy, because say it takes you 6 months to get sworn in, and there's no insurance on a home and something happens to it, then you've lost the only asset in the estate. So pretty much you don't pay any bills when a decedent dies if they're just in their name, except for, I would recommend keeping up insurance policies.
And just keep a copy of your payment, however you make it. You know, if it's a check, if you get the email, if you do it by email and you get an email receipt, just make sure you keep, document everything.
Exactly. Yeah. And that's a really good point. I used to tell everyone to open an Excel spreadsheet, or if you want to do it on a piece of paper, every single thing that you pay for that's estate related before and after you're sworn in, make a log of it. And even if you don't have the receipt, it's okay. You can still claim, and we'll get to that later, but you'll claim it as a deduction on the inheritance tax return. So it's easy to have it in Excel or written down somewhere, because you'll be able to deduct all those items later from the inheritance tax owed. All right. So one thing when you go into the probate office is they're going to ask you the value of the estate, and they're going to ask you to list that value on the estate information form and on the petition for grant of letters. You're going to want to list the lowest amount possible if you overstate the value of the estate, the probate fee is based on the assets in the estate. So if you overstate the amount in the estate, you're going to pay a higher probate fee. And even though they say you can get it back, you will never, ever get that back. So you want to list, you can list, $5. If you don't know, don't list it. And later on down the road, when you file the inheritance tax return, they're going to say, okay, what was in the estate? And then that's when you might have to pay a higher probate fee. But don't pay it up front if you don't know, because you can't get it back. All right, so this is what the estate information sheet looks like. It's the same for probate and for testate and intestate estates, so with a will or without a will. You're just giving the decedent's information and the information about the executor or administrator. And then this is the petition for grant of letters. This is where you're going to list the potential value of the property in Pennsylvania, more information about the decedent, and then most importantly, all of the potential beneficiaries, their relationship to the decedent, and their contact information. Again, this is a form that when you contact your Register of Wills, they'll give this to you. Up here, I don't know if you can see my mouse, but where it says decedent died at, you list where the decedent died, and then right under that, where it has you estimate the value of the property, that's where you do not want to list anything that you're not sure of. So if you think the decedent had a bank account worth $10,000, you don't list that unless you know for sure. If you know they had a piece of property, you have no idea how much it's worth, you have no idea if there's a mortgage on it, don't list it. If everyone's in Pennsylvania, any real property outside of Pennsylvania, do not list. And it's here. It specifies here that all property in Pennsylvania, but just make sure if they have a house in New Jersey or somewhere else, that does not get listed, because that is not subject to inheritance tax.
These forms are may also be available now on the websites for each of the county Register of Wills. Every county is different. I'm pretty sure in Philadelphia it's available.
Yes, in Philadelphia, I can confirm they are. Some counties, they'll email them to you.
Right.
All right, so after you filled out all the appropriate paperwork and you've been sworn in, then you will receive your official letters testamentary or letters of administration. And also receive a short certificate just saying that you as an individual are the personal representative of this person's estate, and it'll have an official stamp, an official seal on it, and that's what you then can bring to the bank or show at closing for real estate to show that you have the authority to sign on behalf of the decedent's estate, and you have the authority to administer the decedent's estate. So it basically gives you the authority to do anything with the decedent's estate that the decedent could have done. And again, with that, you have a duty to act in the best interest, not of the beneficiaries, but of the estate. So if one beneficiary, wants more from the estate, your interest is in what's best for the estate as a whole. And then that in turn is in the best interest of all the beneficiaries as a whole, because it's fair. Once you have your letters of administration, you'll go to the bank and open up an estate bank account. In order to do this, you'll need an EIN number, which is something you can apply for free online. If you just put into Google, apply for an EIN number online, you're going to get a bunch of results. You want to pick the website that has .gov at the end of it.
Right.
because there are a lot of them, you know, there'll be ads, and there are a lot of them that try and look a lot like the government website and charge you to get an EIN, but it's free. So you want to make sure you're on the government website for an EIN. And once you have that, you put in all the information. It's very straightforward, and then it'll generate that EIN for you most of the time automatically. And you can just download a PDF EIN number. And that's basically like the estate's social security number. So you take after you get that EIN number, you hold on to that number forever, do not lose it. And you take that number and your ID and your short certificate or letters of administration, and you can go to the bank to open a bank account for the estate. At that point in time, all the assets, any cash, any accounts that the decedent owned can be transferred into that bank account. If it's money that's not invested, you can just have that transferred in. You can go to the banks that hold the beneficiary's assets and just give them your letters and have them then transfer it into the estate account you created. However, if the decedent had investment accounts that have, that are invested, and you don't want to sell it in order to transfer it, then you might want to open an estate account at the institution where the beneficiary had investment accounts. That way they can transfer them over into an investment account, what's called in kind, which just means if they have one share of Apple stock in their investment account, they open up another account in the name of the estate and they just transfer over that one share of Apple stock. And then basically you want to do that because if you sell that Apple stock and there's a huge gain, there's a huge difference between what the decedent paid for it and what the beneficiary will receive, and the current fair market value, you could have to potentially pay a large amount of tax on that income. And you don't want the estate to pay that because the estate pays a higher tax ultimately. So you want to make sure if there are any investments in the accounts held by the decedent, you want to make sure that you're prudent before you, and the best thing with that is to talk to an accountant before you cash out anything that the decedent owned. So that's just one thing to keep in mind. If it's cash, it's fine. You can just transfer that over into your estate account. All right, so your first step then as executor administrator is to harness all the assets. Once you have a full inventory of what all the assets are, then you have to file a tax return. In Pennsylvania, there is a 4%, there's 0 inheritance tax return for a surviving spouse. There is a 4% inheritance tax on anything that passes to children of the decedent. And there's a 12% tax on anything passing to siblings of a decedent. So depending on what the decedent's assets were, you can download, and this is something you might want to have an accountant do. A lot of accountants do inheritance tax returns, and you can negotiate a flat fee, or you can download the forms online, and you list all the assets on the inheritance tax return. You list anything you have spent as the executor administrator, and that includes if you drove across the state, you can deduct your gas. If you had to go somewhere and stay in a hotel, you can deduct that. You can deduct the entire cost of the funeral. Anything related, anything that's incurred after the decedent dies, you can deduct as a deduction. After that, if
you have calls and they're long distance, if you have to fill out forms and there's charges, all these kinds of things.
Yeah, the probate fees, whatever you pay when you initially probate the estate, anything. The rule is just list it all, and pretty much everything will be deductible. So after you file the tax return, you'll know how much you owe in inheritance tax. So that's the first thing that you are going to pay, is the inheritance tax. And then next, the next line, so when you distribute assets, there's an order of how you distribute them. So that is actually something that you might want to consult an attorney about when it comes time to distribute assets. You want to make sure that you distribute it in the correct order, because you as administrator or executor have a fiduciary duty to not distribute funds to the wrong individual in the wrong amount. So that is, I would say, if you're gonna contact an attorney, it would be potentially to file the inheritance tax return, and then to help you decide the order of payment. So, first you can pay, the things that you're allowed to pay first are the funeral expenses. You're allowed to pay your fee as administrator or executor. You're allowed to pay, then you pay any attorney's fees. And after that, you pay off all debts. If the debts exceed the amount of what's left in the estate, then you have to take whatever proportion of money they owe. You take that proportion of what's left, and that's what they get. After that, if there's anything left after payment of inheritance taxes and debts, then you can distribute the assets per either the terms of the will or the intestacy rules. So I have in here real property. Say you have an estate that the only real asset in it is a piece of property. So if one of the, normally the easiest thing to do is to just sell that piece of property and receive the cash and keep that in the estate account, and then just distribute it per the terms of the will or per the terms of the intestacy laws. Or if one of the beneficiaries wants that house, then you can negotiate an agreement to sell that house to them in exchange for funds. Or say you have $100,000 in the estate in cash and $100,000, and the house is appraised at $100,000, you can distribute, and one of the beneficiaries wants the house, then you can distribute it in equal value. So you can say you have two kids and they're the only beneficiaries, you can give $100,000 to one kid and the house to the other if that's what they agree on. And so after you've distributed all the assets, then you'll circulate something called a settlement agreement. So that means any debtor and any individual that received money from the estate has to sign off saying that they release you and they agree to refund anything. If any debts of the estate arise in the future that you didn't know about, they're agreeing to refund that amount. And mainly the most important thing is that they release you. And after that, then you can close the estate. And that's a form that you also will get from the Register of Wills. So I'd say most times when people, any attorney will tell you 100% need to be released. And I'm not saying that you don't need to be, but if you're administering estate for your dad, say, and he only had, a modest amount of assets, no debts, and you pay the inheritance taxes, you pay yourself the administrator's fee if you want to take it. And then you can just distribute the rest between, yourself and your one sibling. And you could get something, very small in writing from them saying, I release you. Just so you have that in writing. But it doesn't have to be a whole big thing unless you have beneficiaries that don't get along or that you don't know that well. So that's just the settlement agreement. would be something you might need an attorney for if you think it's going to be contentious. But if you're 100% sure it's not going to be contentious, something you can just write up on your own.
An email from somebody saying, you know, thank you, I released all claims, I'm not going to fight this, would be great.
Yeah. One other thing I wanted to mention is that as an executor administrator, you are entitled to a fee. However, if you are the administrator daughter and you're the only heir, whatever you receive as administrator's fee is subject to income tax. Anything that you receive just as a beneficiary, as an inheritance, is not subject to income tax. So a lot of times it is cheaper for a lot of people to not take an administrator's fee because of the income tax that they'll owe.
And you also have the issue, everybody should know, that your fee should be reasonable, because there may be other beneficiaries who will challenge the fee that you get. So just keep that in mind.
Right. And a lot of times there is no set statutory rule for what percent you can take. A lot of times that number falls between 3 and 6%. But again, there's no statutory rule behind it. All right, so sorry, one thing I did not mention is that after you first open the estate, and this is something the register will tell you, is that you have to send notice of estate administration to the beneficiaries and heirs. If it's an intestate estate, you send it to anyone that's entitled to a portion of the beneficiary's estate. And the same thing with a will, even if someone was left out of the will. So if a parent left if the parent wrote one kid, didn't include one child in the will, even though that person isn't included in the will, you still have to send them an estate administration form, because they are, and they would be considered an intestate heir. And you don't have to send them a copy of the will, but you do have to let them know that that estate is being administered and that there's a copy of the will lodged at the register. So if they want to go to the Register of Wills and look at that will, they're 100%, that is public record, and they're 100% entitled to do that. And so those notices do have to be sent out within 60 days of the letters testamentary or the letters of administration. Again, that is something that the register will tell you. And after you send those notices, they're going to ask you to certify that you sent them. So that's another form they'll give you. And you'll just write on that form, I certified, I sent these notices to all the beneficiaries listed in the will and all the intestate beneficiaries. And then in order to officially have the clock start running on the creditor period, you have to advertise the estate in 3 different publications. So that is kind of frustrating, but and again, that might be something that you want to have an attorney do. If you can just negotiate a flat fee and say, I'll pay you $100 to advertise this estate in 3 newspapers, it costs around $400. After they do that, then the clock starts ticking on how long creditors have to come forward and get money from the estate. So it's 1 year from the date that the estate was advertised. Creditors have that period to come forward. If they don't come forward, you as executor are entitled to distribute out the assets in the estate after that 1 year period has run, and you're not liable personally as executor for the whole amount of that debt. So that's another reason too that, you know, a lot of times when people pass away, the heirs want the money right away because they know that the money's in there. But you as the executor administrator do not want to distribute the money out until that year period has run from the date that you legally advertised the estate.
And that's really important, because if you don't follow this rule, you could be personally liable. The creditor could come after you personally. So it's really important that you make sure that it's advertised and then you wait a year.
Again, this is the form we were talking about before, the notice of estate administration that you have to send out to all the beneficiaries. And so this is just what the form looks like. All right, so most of the stuff I talked about before, but one thing I want to add is when you file after the beneficiary dies, you have 3 months to make a prepayment of inheritance taxes. So basically you add up all the assets you think are going to be in the estate, you subtract maybe $10,000 that you think are going to be there for deductions. So like, you know, most funerals are pretty expensive, you deduct that. So you just estimate what you think the deductions are going to be. And then you take, depending on, say it's a child beneficiary, you take the value that you think the estate is, an estimate, you deduct an estimate of the deductions, and then you take the rest of that and you multiply it by 4.5%, which is the inheritance tax. And then you take that number and you deduct 5% from that. And that's, if you pay that amount before within 3 months of the decedent's death, then you get that discount of 5% on the inheritance tax that's due. A lot of time, people, since COVID started, no one's been able to even open an estate. So no one's been able to get that prepayment in. But if you can't, do not worry about it. A lot of times it saves you maybe like $100, $200, depending on how much is in the estate. So it's really not something, even larger estates, it's not something you really have to, don't super stress about it if you can't. Don't hire an attorney to get it in right away, because that attorney will probably charge you more than you would save. But that's how you do the calculation, just so that you know that is the discount. And then 9 months after the date of death, that is when the payment is due for the inheritance taxes due on the estate. And even if you get an extension on filing the return, you have to make that payment at least within 9 months. Otherwise, it accrues interest. So when you file the inheritance tax return, that's when you file the inventory with the Register of Wills that says, okay, this is what was really in the estate. So if you didn't list the full amount of what was in the estate on the initial probate petition, then that's when you pay the extra fee potentially for the additional assets in the estate. This is what the inventory form looks like. You file when you file this at the Register of Wills, you file it with the inheritance tax return and then 2 copies of this inventory. These are the inheritance tax rates. Sorry, I think I said 4% at the beginning for direct descendants. It's actually 4.5%. Siblings are 12%. Anyone else, friends, 15%. If someone leaves money to charity, that is taxed at 0%. Again, what I want to highlight here is when you pay off the debts, if there's no money in the estate, if there are $50,000 worth of debts and $5,000 worth of assets in the estate, you do not have to pay off with your own money the rest of these debts. The only thing that creditors are entitled to are what's in the actual estate after payment of the funeral and attorney's fees and administration fees. So it's really a judgment call. And a lot of people too might say, you know, before they even get sworn in as executor, executrix, or administrator and administratrix, you want to evaluate what's in the actual estate. If you think that the decedent had more debts than they did assets, it's not worth even opening this estate, because once you do, then you're responsible for harnessing all these assets and paying off these debts, and you'll get likely very little in the end. You know, in that case, if the debts outweigh the assets in the estate, you can still take your administrator fee before paying off any debts, But, you know, if depending on what assets are in the estate, the administrator fee might not be worth it for all the headache that you will go through in administering an estate that doesn't have more assets than it does debts, which is just called an insolvent estate. So before you even get sworn in, really evaluate what's in this estate and what potential debts are out there. All right, so this is for when I was talking about distributing assets in a certain order. It's a statutory order, and I think I can get you the exact, it's a statutory list. And so a lot of times you can get this from the Register of Wills, and it tells you the exact order. So here it says, you know, you can, before any debts, you're allowed to distribute your administrator's commission, because if we didn't have an administrator working on these estates, then there would be no one to pay the creditors anyway. So we pay them first before we pay creditors. Again, this is for any real property. If you have to sell real property, it's as though you were selling property yourself. You're just representing the estate. So again, you can use a realtor and you'll sign any deed on behalf of the estate. And a lot of times, if you want to sell a piece of property, just don't be surprised if at closing they require you to, any proceeds of the property, they'll hold back an amount equal to what they think the inheritance tax will be on that piece of property, and they won't release it until you have filed the inheritance tax return and proven that you've paid the inheritance tax due on the estate. So that's kind of the one big difference when you're transferring real property from an estate versus an individual. And in addition, they will also look up any debts that the decedent might have had, and they also might hold those in escrow. If there are any, you know, if there are any judgments against them, they might hold those in escrow as well, unless you can prove that they were paid, or that sometimes they won't know it's not a money judgment. They'll just see a judgment on there, and they won't see that it's paid, and they'll just retain those funds at settlement. So it's really important when you go to settlement, if they're going to retain money for inheritance tax, there's really not much you can do to get around that. But, you know, if you haven't already filed the inheritance tax return, but if you, if they want to hold money for other judgments, then you can call your courthouse and just get something in writing that you can give to the title company saying that this judgment has been satisfied, and they won't withhold any more money at escrow. And then again, I would say work with a realtor if you're going to sell a piece of property, and they also can walk you through what you need to sign as executor, and the title company will give you all the documents that you need to officially sign. If the decedent had a piece of property, say you're in Pennsylvania, and the decedent had a piece of property in New Jersey, you'll have to open up another estate in New Jersey, and it's just called ancillary probate. You do have to, you'll have to work with their Register of Wills, and they'll request a certified copy of your whole probate package from Pennsylvania. Pennsylvania will send that to the New Jersey Register of Wills, and then New Jersey will give you will open an ancillary probate estate in New Jersey, and you'll need to do that before selling a piece of property in New Jersey. No state will allow you to handle any assets of a decedent of that state if you don't have specific letters from that state's Register of Wills in the county that, it doesn't really matter what county actually. If say the decedent owns several properties in New Jersey, a lot of times you can just open up ancillary probate in one county, but it does have to be in the state. And again, that's something that the Register of Wills can help you with. And it's something that your realtor, if you work with a realtor, will bring to your attention most likely. And if they don't, then then the title company will. All right, and so once you've filed the inheritance tax return, paid off all the debts, distributed all the property, gotten the appropriate releases, then you file this status report with the Register of Wills saying that it is closed. They might ask you for a status report before, say, it's a year and a half since the estate was opened. They might ask you for the status report, and you can just say, if it's still in progress, then you'll just state that on the status report. A lot of times they won't really ask for a status report, and you can just file this when it's done. So at the end of this PowerPoint are the contact information and addresses of lots of Register of Wills offices in Pennsylvania. So I can go through these, or I don't know, Debbie, are you going to send this out or make it available so people can?
Yeah, we are going to send it out, and it looks like some people are from Philadelphia, so that won't even matter. But we can add to it, I don't know if we have it in this or not, we can add to it information for Philadelphia County.
Okay.
With the advent of Zoom, right, people can come, participate from across the state, so that's fine. Thank you so very much. This was amazing. It is very complicated, I know. And I don't know if any of the participants have any questions that they want to ask. I want to give a caveat. We are not giving legal advice, but we are more than happy to answer questions. I think I see Rashida's hand.
Yes, thank you. Thanks, everybody. I have a question regarding real estate property. My parents' home, my mother is deceased, and I've learned that when the insurance and stuff comes in, they still have her listed. She's been deceased for since 2001. And so it's my dad, and the house is paid off and everything, but apparently she's still on it.
Mm-hmm. So if you're keeping it up, I can't really say what an insurance company will do, but it is best, just because if this is a valuable asset, it's paid off, there are no debts. You want to make sure that if something did happen to it, the insurance company doesn't come back and say this isn't a legitimate policy because she's not the real owner. So in that case, you might want to, sorry, what were you going to say?
I was going to say, has the ownership of the property been transferred, or is it still in her name?
He hasn't done anything. It's in both of their names. Yeah.
Right.
Oh, it's in both of their names?
Mm-hmm.
Oh, okay. So depending on what it says on the deed to the property, do you know if they were married when they purchased it?
No.
Okay. So do you know if it said, do you have the deed with you?
No, I think I probably could grab it if somebody else had a question and we're still on the line.
Okay.
Or you can even email us and we can address it too.
Right.
Okay.
That way you're not getting any personal information if you want.
Thanks.
Definitely.
All right.
But yeah, it was like, back when folks were common law and, they bought a house together, and she passed in 01 or 02. And just nothing else further came, and he just finished and paid it off and what have you. But with that insurance that comes, she's still on there, and she is on the deed.
Okay.
And your father's still alive, correct?
Yes.
Yeah, you probably just need to notify them and change the ownership.
And also, if they owned that property, which I can't obviously tell you 100% without seeing the deed, but I'm almost certain that that deed was owned as joint tenants with rights of survivorship, which means when your mom died, you didn't even have to change the language on the deed. It automatically, the whole interest in the property vests in your dad. regardless of what it says on the deed. Name on the insurance policy. Okay, so in that case, you can just call up the insurance policy carrier and say, you know, this property was owned by my parents. My mother is no longer alive, but my father is. So you can just remove her name from the policy. And they'll probably request a copy of the deed if they don't already have one. But yeah, as long as he owns that property and his name is on the insurance policy, I think you're fine.
Thank you. Would it specifically say right to survivorship on there, or it would?
It might say.
It sometimes does.
Joint tenants. It might say JTW RS.
Right, RS, right.
Yeah. And I'm going to just look up something really quick. Whether property automatically becomes, and you said they had a common law marriage?
Yes.
So normally property doesn't automatically become tenants by the entireties when you get married. So if you purchase a property before you know, with someone you're dating or a partner before you get married, and you don't list on, and you list on that tenants in common, which just means that you each own 50% of the property. If you get married, it doesn't always automatically become owned as what's called tenants by the entireties. So tenants by the entireties means if two people own it, it's tenants by the entireties. When one person dies, the entire thing vests in the survivor. If it's tenants in common, when the one owner dies, 50% of that property goes to the decedent's heirs, which that would be your dad and you guys, if your mom didn't have a will, and then the other 50% would remain with the survivor. So I think there's probably a really good chance that it was owned joint tenants, but yeah, we just have to see the deed to confirm it.
Okay. Thanks.
Okay.
Thank you.
Well, it is 8 o'clock, and I want to thank everybody for listening, asking questions. Flora, thank you so much for doing this. This is wonderful. And have a great Memorial Day weekend, everybody. And we will get slides. We will get the slides out to everybody who's participated. And thank you very much.
Thank you very much for this. It's very informative. Thank you.
Thanks.